Hello everyone, myself Mahima Khurana. Welcome to LawSikho. Today I will be dealing with the CRPC module and the first chapter. The first chapter is Introduction to the Law of Criminal Procedure. In this chapter, we'll get the answers of questions like what is the nature of Criminal Procedure Code? What are its objectives? What was the need to involve such a comprehensive and lengthy procedure into the Indian legal system? And maybe how it came into being, and etc. So let's move on. Before getting into the details of introduction, it is very important to understand what is a crime, because after all, a criminal procedure code stands on a criminal branch. It is a branch of a criminal law. So let's start. A crime may be defined as an act or omission which a society has thought fit to punish. So you can highlight 3 points here: act, omission, and punish. Act is a positive act, and omission is an omission to do something which a person was bound to do by a law. And punishment, from the definition itself, it is very clear that the end result of a crime is to punish the offenders. And here's why a crime is differentiated from a civil law. Criminal law is different from civil law, as I've already stated, because the end result of a crime is to punish, of a criminal law is to punish an offender, while the end result of a civil law is to to provide compensation to the aggrieved party. While a criminal law is always against the state, it is always against the society on a whole, while a civil law is always against an individual, one individual, or maybe an organization, but never against a state. So criminal law is different from civil law, and that is why we are studying a different procedure for criminal law, and there's a different procedure altogether for civil law, and that is Civil Procedure Code. Let's move forward now. To protect crime, IPC is designed in India. IPC is Indian Penal Code. Indian Penal Code of 1862 is designed in India to protect a crime. What is a crime? We have already discussed a crime, and various offences have been mentioned under Indian Penal Code. And to protect them, punishments are also prescribed under the same code. So to protect crime, IPC is designed. The Indian Criminal Procedure Code is designed to provide a machinery for the enforcement and administration of substantive criminal law in India. Without the Criminal Procedure Code, the substantive criminal law will become meaningless. Point out, guys, without the Criminal Procedure Code, the substantive criminal law will become meaningless. Yes, because the Criminal Procedure Code is one which provides a machinery, which provides the procedure for enforcement of those crimes which are mentioned under IPC. For example, if a person has committed theft under section 378, suppose, so how will he get punished? What should be the rules of proceeding? How his trial should be conducted? What are the evidence which are need to be collected by the prosecutors, and etc. All those rules are mentioned in detail under Criminal Procedure Code, which we'll be studying under future chapters. So let's move on now. Historical background. Historical background is how the Criminal Procedure Code came into being, how the present code of 1974 came into being. There were no fixed rules of procedure to be followed in criminal trials until the year 1882. As we all know, it is a well-known fact that earlier, the only person who used to give commands, who used to decide the rules of procedure, who used to give punishments, or who used to decide how a proceeding should be conducted, how a trial should be proceeded with, what should be the deciding factor for deciding the guilt of an accused, was the king. The king was always the person who was supposed to be always right, right? So there were no fixed rules of procedure to be followed in criminal trials until the year 1882. And for the very first time in 1882, the Code of Criminal Procedure was enacted, The procedures were set in the year 1882 for the very first time for the whole of India in the presidency towns. Presidency towns means for Bombay, Calcutta, and Madras, which was replaced by the Code of Criminal Procedure Code 1898. 1898 replaced the earlier code of 1882. The code of 1898 underwent radical changes by the acts of 1923 and 1955. This is not important, but the only year you have to remember is 1882 and then 1898. The Law Commission suggested changes in the Code of 1898 because of the loopholes and because of the various limitations found in the Act of 1898. The Law Commission suggested the changes because it was very lengthy and the procedure was in a haphazard manner. So, to cover those loopholes, Law Commission suggested changes in the Code of 1898. The final comprehensive report was submitted by the Law Commission in 1969, making detailed recommendations. Accordingly, a draft bill was prepared and passed by both the houses of the parliament, and the present code was enacted. It received the assent of the president on January 25th, 1974 and came into force on 1st April 1974. Remember the date, guys, 1st April, because the date had been asked in various examinations. In various previous year questions you might find this question, that on which date criminal procedure code came into force, and the answer is April 1st 1974. You have to remember the date, April 1st 1974. Let's move on now. Nature of criminal procedure code. What is the nature of criminal procedure code? As in the first slide itself, it was stated that a criminal procedure code give meaning to a substantive criminal law. What is a substantive law? A substantive law determines the rights and liabilities of the parties, like Indian Penal Code. Indian Penal Code determines the rights of a victim while liability of an accused, if at all his guilt is proved. Then, and how the guilt is proved? Through the procedures laid down under Criminal Procedure Code. Procedural law lays down the practice and procedure for enforcement of those rights and liabilities. As I've already stated, that it is procedural law which state the practice and procedure for enforcement, how those rights and liabilities should be enforced, how those rights and liabilities should be executed, is dealt under a procedural law, and which is Criminal Procedure Code. The Code of Criminal Procedure 1973, after coming into force on 1st April 1974, provided proper machinery for crime detection, evidence collection, apprehension of suspected criminals, determination of guilty person, and his punishment accordingly. Thus, it is a procedural law, as it in detail mentions the procedure for the enforcement of those rights and liabilities which are mentioned under substantive criminal law, and which is IPC or any other substantive criminal law. Procedural law provides detailed machinery for enforcing various criminal law and criminal codes, and lays down the procedure for trial of offenders while ensuring the principles of natural justice. Under CRPC, there are around 5 kinds of trials mentioned under different chapters. So the trial part, how the trial should be proceeded, how a person should be stand in court, and how the guilt of a person should be proved, or how his innocence should be proved, is ensured by a fair trial, and that fair trial is ensured by the principles of natural justice. What are the principles of natural justice? Principle of natural justice, one is rule against biasness. The panel of judges should not be biased while deciding the guilt of an accused, or while deciding the end result of a case. And then one more principle of natural justice is audi alteram partem, right to be heard. Every accused should get a fair opportunity of being heard. Okay. So this was it about the nature of Criminal Procedure Code. Let's move forward now. Importance of criminal procedure. As we have already learned that a substantive law is very important, because the substantive law is the base. Substantive law creates the rights and liabilities of a person. It decides what is a crime and what is not a crime. Okay, so the procedure for enforcement of those deciding factors are laid down under Criminal Procedure Code. So without a procedural law, a substantive law would be meaningless. So its importance should not be underestimated. A procedural law, or for the matter of fact, a criminal procedure code, is equally important as a substantive law like IPC. The procedural law administers and enforces substantive law by providing appropriate machinery. The efficacy of substantive law largely depends upon the effective implementation of procedural law. Thus, the procedural law puts life into substantive law. In Joginder Kumar versus State of Uttar Pradesh, the Supreme Court has stated that the quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of criminal law. This is the importance of a procedural law, that the quality of a nation, civilization, how a nation is good, is decided by the quality of a procedural law it has. Okay, so its importance is very high. Applicability. On what offenses a criminal procedure code applies? Like it cannot be applied on all the offenses, because special acts have their own procedure, while some acts always follow criminal procedure code for their procedure. So let's study section 4 and section 5. Section 4 basically talks about the applicability of criminal procedure code. Section 4: all offenses under IPC shall be investigated, inquired into, tried and otherwise dealt with according to CRPC, while all offences under any other law shall be investigated, inquired and tried and otherwise dealt with according to the same provisions, but subject to any enactment for the time being in force regulating the manner or place of investigation, inquiring into, trying or otherwise dealing with such offences. So guys, this section can be bifurcated into two heads: offences under IPC and offences under any other act. So all offences under IPC are to be dealt in accordance with criminal procedure code. This is a mandatory requirement. Okay. While all other special laws, if at all it mentions that the procedure for a special act should be governed by CRPC, then CRPC comes into play. But if it mention any special act, or if it mentions the act itself, for example, Custom Act mentions that the procedure should be governed by the rules set out in the act itself. So it will be governed by the same act and not CRPC. But if at all it does not mention any procedure, then CRPC comes into play and the procedure should be governed by Criminal Procedure Code. Section 5. Nothing contained in the code, this is a saving section, nothing contained in the code, in this code shall, in the absence of a specific provision to the contrary, affect any special or local law for the time being in force, or any other special jurisdiction or power conferred, or any special jurisdiction or special powers conferred, or any special form of procedure prescribed by any other law for the time being in force. It means that section 5 saves CRPC, saves other law over CRPC. CRPC will not override over other laws. Again, Custom Act, Custom Act prescribe a whole different procedure for confiscation of property, while CRPC provides a different procedure. But since Custom Act is a special act, okay, so it will override over CRPC. CRPC will not be applicable on Custom Act, but if any act does not mention any procedure, then the general law will be CRPC. Okay, and one more thing, guys. The scope of Criminal Procedure Code can be traced from these words: shall be investigated. So yeah, these three words: investigated, inquired and tried and otherwise dealt. That means the procedure for investigation is covered by CRPC. Okay, we'll be going through that chapter also. Investigation procedure is dealt by CRPC. How a police officer, or for a matter of fact, a private person also investigates into a case. That is pre-trial. Okay, before trial. The whole CRPC is divided into 3 stages: pre-trial, trial and after trial. Okay, so investigated, inquiry is always done by a magistrate or a judicial authority. So investigated, inquired and tried. Tried means trial, which takes place in a court. So, and otherwise dealt, that means there are also other provisions other than investigation, inquiry and trial, like maintenance proceedings, like deciding the jurisdiction of a court, like how a case should be governed, what should be the procedure for trial, that is covered under trial. But otherwise dealt is a wide word which covers all other aspects other than investigation, inquiry, and trial, which we'll study in other chapters, upcoming chapters. So this was about the applicability. Let's move on now. Exhaustiveness. Exhaustiveness, the word exhaustive means complete in itself, whether CRPC is complete in itself or not. So the preamble of the code provides an act to consolidate and amend the law relating to criminal procedure. The word consolidate itself denotes its exhaustive nature. That means CRPC is exhaustive in nature. It is complete. But if at all there is a need, if there are any specific provisions not made by the court has inherent powers to change the procedures. Inherent powers are mentioned under section 482 of the new act, the act of 1973, the criminal procedure code 1973. Section 482 empowers a high court to exercise inherent powers for inculcating those provisions which, if there's a need, if at all there's a need, so the high court can interpret the law and also include those provisions which are not included in the present act. So overall the act is exhaustive in its nature, but there is also a provision by the name of inherent powers, which can be any time used by the High Court to complete the provisions which are not mentioned under CRPC. Okay, now let's move on. Prospective in nature. Do you know what is prospective means? Prospective and retrospective. These are the two terms which you might have heard earlier also. Retrospectivity is a term which means effect from back date. That means if at all a law is retrospective, then it will have the applicability from the back date. But if a law is prospective in nature, then it will be applicable from the date of its enforcement. So procedural laws are retrospective in operation. This is a general rule that procedural laws are retrospective in nature, in operation. But similarly, all substantive laws are prospective in nature. That means all procedural laws will have their applicability from the back date, even before the date of their enforcements. But this CRPC is an exception to this rule. Yeah, CRPC is the only exception to this rule, that since all procedural laws are retrospective in nature, CRPC being a procedural law is prospective in nature. Yes, CRPC is prospective in nature. Okay. So this principle has exception in the name of Criminal Procedure Code. The CRPC is prospective in nature. That means before the commencement date of Criminal Procedure Code, that is 1st April 1974, if at all an offense is committed, and if it has to be decided according to which provisions the offense should be tried with, then the act would be of 1898 and not of 1973, because it is prospective in nature and it does not have applicability on the offenses which have committed prior to its enforcement date. Okay, this was all from my side, guys. This was about introductory part of CRPC. We'll be dealing with other chapters also soon. Till then, thank you.